Good morning, everybody.
Good morning.
Thanks for coming to our training class with our association attorney, Wayne LaRue Smith. We're going to go over the changes to the FAR-BAR contract, FAR-BAR 2, I think it's called.
Yep.
So, a couple of items. We're going to have, you can ask questions, but if you would like to ask a question, please come up to the front and then cross over to the microphone there by the podium. You can stand next to the podium and ask your question. Use the microphone, and Wayne will recognize you when he's ready to answer your question. So feel free to walk up there anytime you have a question. There's a pretty good turnout here. I'm glad to see you all. There's a good possibility that if there's enough interest and you spread the word about how great this was and how necessary it is for professionals to be well versed in the contracts that they use, we could schedule another class depending on the interest that we hear. So we'll keep that in mind too. And with that, Mr. Smith.
Great, thanks. Thanks, Michael. And thanks for being here. One more thing about the questions. It's really okay with me if you ask a question at any time. Sometimes it's easier to have it make sense to everybody if it's at the time we're talking about the particular contract provision rather than waiting until the end. But there'll also be an opportunity at the end. And sorry about the rather cumbersome procedure, but the seminar is being videotaped for future use, and your questions won't show up on the recording if you're not next to a microphone. Did everyone get a green folder? Let me explain what's inside there. We're going to be talking today first about a contract that probably most of you don't use very often, but I think it's important to understand that Form 1 because someone else might, and you need to know it. And the as-is contract is an adaptation of the what's now the FAR-BAR 2 contract. So I'm going to take it in that order. I'm going to talk about the standard contract that includes an inspection and repairs provision. That's the primary difference between that and the as-is. I recognize you don't use it very often, but you can rely pretty significantly on the conclusion that if it's in the standard contract, except with regard to inspection and repair provisions, it's in the as-is contract. But then I'm going to walk through the as-is and talk about the changes that are unique to that. Accordingly, just know that anything we say for the standard FAR-BAR 2 applies to the as-is contract unless I tell you otherwise. So in your package, you have what is now called Florida Realtors, Florida Bar Residential 2, I believe is the, no, just -2. It's in two formats. One, a red line format, and the red line format has all of the deletions stricken out, so there's a line through them, hopefully in a way that you can still see what it was that was taken out. The additions are in red so that you can easily see what was added. And then if there is any commentary, it shows up in a light blue. My recommendation is, as you follow this, you may want to follow that particular form. I also have, although it's marked as a draft, do not use, because it, as of the printing of these materials, it wasn't in final form. The only thing that might change is some formatting. But you have a copy of it without the red line. That is, with all the deletions deleted and all the additions added in. You have that for both the FAR-BAR contract itself, the FAR-BAR as-is contract, and for the comprehensive rider. You should have both of those. I've also included a compact disc. You have all of these documents on PDF format if they're useful to you for some reason. I also included this PowerPoint presentation, again, in case that's useful to you, or if you're feeling really confident about it, if you want to, review the materials with someone in your office who wasn't here, hopefully that'll be a useful tool. And I think everyone who's been to one of our get-togethers before knows that if you ever have a question about any of these forms, please feel free to call me. Sometimes my schedule is such that I can't call you back immediately that day, but my staff will schedule a time for us to talk on the phone, and I'd be happy to answer your questions if something occurs to you after today. You know, as often happens when you start actually trying to put this into practice. So, we're going to be a little bit pressed for time, but I'm going to try and cover every single change, even if it's with just a couple of words. Starting with the FAR 2 contract. It's got a new number, Florida Realtors, Florida FAR-2, with a new revision date of 8/13. For those of you who have been using the 2010 version, you'll start to notice that several of these changes are based on a conclusion that the changes made in 2010 turned out to not be as good an idea as we thought they were at the time. So in some ways, it's sort of a reversion back to, I think, 07 was the previous version. Section 1D, personal property, that about inch-long high section where you checked off what items of personal property were included with the conveyance, that's gone. And we're back to a standard list. It has added to the standard list refrigerator or refrigerators, storm shutters panels, and smoke detectors if those things are owned by the seller. So, you know, it's 3 more things to pay attention to as to what you should exclude. Because the effect of this is, if there's no change to it, everything that's in that list of personal property should be on the property on the date of closing and should convey to the buyer. So, for example, if there's a refrigerator and it's, you know, a tenant owns it and not the seller, it's incumbent upon you to put into the excluded items that item that either doesn't exist or the seller doesn't own. It's the date to determine personal property is the date the initial offer is made. Kind of makes sense that one could assume that a buyer was taking into account everything about the property when they first made an offer. If any items of personal property are to be either included or excluded, you would want to add those in the blank lines provided. Section 2A, the initial deposit. What was deleted was a checkbox in the previous agreement that provided the option that the initial deposit was to be made upon acceptance. And it added a default provision. And this is, you know, I generally advocate to everyone that I advise or work with that when you go through this form, deal with every single blank. Now, of course, if it's an either-or blank, how you deal with it is you've checked one of them. Or, in some cases, if it's appropriate, line through it. It's not a good practice to rely on the default provisions because they're equally as effective as any other provision of the contract, but they're called default for a reason. It's because nobody addressed it. And generally speaking, I think that it is always better to deal with the blanks in one fashion or another. Check it off, cross it out, you know, pick one if there's multiple variables. Here there is a default provision that directs that if there's if it's left blank, the initial deposit is to be made 3 days after the effective date. And the effective date is now defined differently. I think it's one of the most significant changes in the form. We're going to get to that, but pay attention to that one. For any additional deposit, the default provision for the buyer to make an additional deposit was extended from 3 days to 10 days. You don't have to live with a default provision in the agreement. I mean, this is an agreement that I'll go back to Peter will remember this. I don't know if people who attend law school today would remember it. There's a concept that my contracts professor called the battle of the forms, because so many things in the commercial world for so long have been dealt with by form agreements. So we've got a level of priority, and that is that the highest priority is given to any handwritten provisions. And the next highest priority is what we used to call typewritten provisions. Some of us remember a typewriter. And how that's interpreted today is any data that you would type in on your computer to populate or to fill in a blank. That would be the next priority if there's conflicts and you have to decide what's going to prevail, what did the parties agree to. And then finally, the standard pre-printed terms itself would be the third layer of priority in any circumstance where it's not clear or there's a conflict within the document as to what it is the buyer and seller intended. And this doesn't relate to just the changes in this agreement, but I think it bears repeating and remembering that when parties get into any kind of dispute, conflict, or difference of opinion as to what it is that they agreed to, if they were to go in front of an independent, neutral decision maker, a judge, a jury, an arbitrator, someone who's going to choose, the obligation of that decision maker is to first look only at the contract. Seller, be quiet. Buyer, be quiet. We don't want to hear from you. If we can determine what we think is the agreement you made from this document, then nothing else comes in, with, of course, some exceptions, because there's always exceptions in the law. But it's important to remember, because this document, probably your most often used tool in your professional practice, has incredibly serious implications. And there are oftentimes situations where there won't be an opportunity at a crucial, important time for someone to say, oh, but wait, what I really meant was. And so for that reason, you know, my standard is, if your grandmother would understand it and have no questions, you're probably in pretty good shape. And if you're in doubt about whether something should be included, add an addendum if necessary. Because remember, on an addendum, if it's handwritten or if it's typewritten using computer software to add the provisions, it's going to take precedence over any pre-printed provision in the agreement. Back to, where was I? The effective date. The effective date, as I think most of you know or have treated as always being the date on which the last signature or initials were applied to an agreement. You know, when you go through offer, counteroffer, counter-counteroffer, revisions, well, addendums are different if they occur after the effective date. It is now defined as that date or the delivery date if the delivery date is different, which would usually be later then, because you can't really deliver a signed agreement until it's signed. But so, for example, you have a circumstance where you have someone sign the agreement on Sunday or in the evening, or some other circumstance where the broker on the other side of the transaction is not available to receive, or you don't have the ability to transmit, your computer's down, doesn't matter. If it gets delivered the next day or even the following day after that, that becomes the effective date. And as we all know, virtually everything from the date the contract goes hard, the parties have agreed on all the material terms, and the closing, all of the dates in between are driven by the effective date. So it's delivery. It's not just date and sign. Maybe a hard habit to break, because I don't know about you all, but I'm routinely just going and saying, all right, let's just look and see what the last date was. And one of the challenges is there isn't like a really clear, prominent place to record or memorialize when delivery took place. So if you hand deliver it, at a minimum, make a note on your file copy that you hand delivered it. If you transmitted it by email, Do it using an email program where you have a saved copy of the sent transmission and it's not sitting out on a commercial email server where it may be deleted. They're pretty aggressive these days, just to avoid having to respond to a lot of requests, of deleting things like really quickly. Have some means. I recommend, if you use one of those file folders where you've got like checklists and places to put notes as the transaction progresses, add to it a delivery date and a delivery method and the person who has knowledge that the delivery took place. So, for example, if you have an assistant and you say, here, get this over to Mr. Salazar, who's waiting to receive it, make sure your assistant understands that they're going to be the one that if there's ever a question, that's who we're going to ask, the person who affected the delivery. Occupancy and possession. This is Section 6B of the agreement. There's a new checkbox to use if there will be tenants or occupants, including a seller, under an agreement where the seller will occupy the premises post-closing, or future leases on the property that's being purchased. This paragraph directs that the buyer must either receive the written leases or a written description where the leases are verbal, right? If it's a month-to-month tenancy, nobody's put anything in writing. The seller needs to put into writing, here's what the deal is, the tenant, the rent, you know, everything that a buyer of property would typically want to know about the terms of it. And that delivery of those leases or that summary of verbal leases must take place within 5 days after the effective date. And again, don't forget, I'll remind you more than once that the effective date is now driven by delivery of the signed document and not necessarily the date that it was signed. The buyer has 5 days after receipt of the leases or the written summary to terminate or cancel the contract. It's sort of like the inspection period. There's no standards. You know, the seller can think they're the greatest leases on the planet, but if the buyer doesn't like them, isn't satisfied with the terms, buyer has 5 days to terminate the contract. Just to note, previously Standard D of the 2010 version of the agreement provided that the leases were provided 5 days after the conclusion of the inspection period. The idea here was that in all likelihood, this 5-day period is going to occur within any inspection period and doesn't, in effect, now extend the inspection period, right? Because there might be a circumstance where the inspection period goes by, the buyer doesn't cancel, the buyer decides that they want out. Under the old standard, the buyer could just say, I've got 5 more days to say, I don't like the leases, irrespective of whether that's the real reason. So that's no longer possible. Financing, paragraph 8B, like boy. It added a new checkbox with the word other, and a blank line to describe the loan that the buyer will seek if the loan is not conventional, FHA, or VA. So you could insert, I know it's not very common, particularly in like a single-family residence sale, but if there was a USDA loan, an FHA 203K loan, or some other loan, that could be inserted where the buyer previously didn't have the ability to do this in the financing provision. The blank line that was used to describe the loan, sought as a dollar amount or the percentage of the purchase price, was replaced with the term loan amount as defined in paragraphs 2C. A default of 30 years was added to describe the term of the loan being sought. If it isn't filled in, that's one of those that, again, I think really important that you fill it in. There's a default provision, and it may not reflect what the parties intended. The contract was reworded with regard to the parties' rights to cancel if the loan commitment was not obtained by the loan commitment date. This is, I expect most people will agree with me, a fairly common circumstance, sort of an area ripe for problems between buyers and sellers. This whole issue of, did the buyer diligently pursue financing? Did they do it within the time required? Did they follow up with a diligent response to any reasonable information requested by the lender, etc.? Was notice of either loan commitment or denial of a loan timely provided? And here's what applies now. A buyer is obligated to notify the seller upon receipt of a loan commitment. And it doesn't matter if that loan commitment arrived 10 days into a 30-day period or on the 30th day. There's an affirmative obligation that when the buyer gets the commitment, it needs to immediately be communicated to the seller. If the buyer fails to obtain a loan commitment within the time required, the contract states that either party, the seller or the buyer, can cancel the contract after that date is passed on certain specified conditions. Cancellation can occur on the earlier of 1, the buyer notifying the seller in writing that a loan commitment was obtained or that the buyer had waived financing. Said differently, even if the seller had the ability to cancel, let's say it was a loan contingency 30-day period, the 31st day the seller calls up listing broker and says, cancel. You told me I could cancel if I didn't have a loan commitment. Do that. And before the cancellation gets delivered, the loan commitment arrives. That contract's not canceled and the buyer's safe, even though it was a day after the period. And the other is under the earlier of standard, 7 days prior to closing. If neither party timely terminates, the provision regarding the financing contingency is deemed to be waived. So if nothing happens, buyer doesn't say one way or the other, I did get financing, I didn't, here's my letter, here's my proof. Seller didn't do anything, just ignored the fact that the time period went by and nobody dealt with it, then it's waived and both the buyer and seller are obligated to close.
Say that again.
Yes. If nobody does anything, if you have a financing contingency in the contract and there's no further communications between the buyer and the seller with regard to whether loan commitment was obtained, not obtained, or waived, then the default provision, if you will, is that it's deemed to have been waived by the buyer. So, again, this is... It's still going on. It's as if the financing provision was never in the agreement. So that's one of those circumstances where the effective date's really important because the financing contingency period is usually measured from that date, and the importance of I know that when we handle a closing, the very first thing we do is put into the calendaring system all of the critical dates. And then we note those dates that can move, right? Because sometimes you have a period to do something, maybe it's 30 days, and it's done on the 20th day. It's no longer then, the follow-on activity is no longer measured from the expiration of the period. It's from the date that the event occurred. So it's kind of a dynamic thing, the dates, they can move. Yes, Scott.
Just want to clarify that I understand this. The buyer says to the agent, cancel the contract, I haven't received my loan commitment yet. The agent delivers the cancellation to the listing agent. The buyer the following day gets loan commitment. That contract is still alive?
No, it is not still alive. And the reason is that on the first day of those 2 days, and by the way, the question was, if it didn't get picked up on the recording, is suppose a circumstance where a buyer at the appropriate time calls buyer's broker and says, I didn't get my loan commitment, tell him the deal's off because I didn't get it. And I'm going to assume for purposes of your question, the listing broker diligently did that. Hung up the phone, typed an email, picked up the phone. Phone's usually not a good idea for things like that because a solid paper trail on important events is always important if there are questions later. So on that day, contract is canceled because of no commitment. The following day, the buyer gets a commitment and rushes it over to the seller's broker and says, I've got the commitment, we're in. The contract was terminated on the first notice. So the loan commitment, it becomes interesting. Maybe the seller's going to say, well, that's okay with me. We'll just reinstate the contract and deem the financing contingency fulfilled. But it would be up to the seller in that scenario.
So in that scenario, let's say the seller gets the sense or is of the opinion that the buyer has not really tried and is using the financing contingency to back out, knowing full well that they're going to get it but they haven't received it yet. Is the seller obligated at that point to cancel the contract?
No, the seller is never obligated to cancel the contract because remember, the default provision in the agreement is that if nobody does anything with regard to financing contingency, waiving it, fulfilling it, or giving notice that it wasn't fulfilled, loan was denied, then it's deemed to be waived altogether as if it was never in the agreement. So the other point about that is, and I lost my train of thought.
The buyer's agent shows up and says, my buyer wants to cancel, he hasn't received loan commitment yet, but there's still 10 days left in the loan contingency.
Oh, okay, and the other piece of your question was, and if the seller suspects that the buyer didn't really try, and that the claim that the loan was denied is a subterfuge to get out of an agreement because the buyer's changed his or her mind.
They need a denial letter in that scenario?
Well, it's advisable. I mean, personally, that would be my standard practice, is to get a denial letter, because that resolves a lot of questions. If it's just an email from the buyer's broker, sorry, the bank said no, it's more likely that the seller's going to be inspired to go, well, did this buyer really even try? Whereas if you've got a letter on the letterhead of a lender that says, thank you for your application, it's being denied, the law requires that they tell the reason for being denied, most likely the seller's going to assume that the buyer timely applied and fulfilled those requirements that are not in the contract itself, but they're presumed in the law. Things like when a buyer requires a loan contingency in a contract, that buyer is obligated to diligently pursue obtaining financing on the terms defined.
So let's say at that particular moment the seller says, no, I'm not canceling the contract. I want you to try harder. What happens then?
The question is, what if notice goes from the buyer to the seller before the expiration of the loan contingency period, I've been denied, the deal is off, and the seller says, you didn't try hard enough, go back and try some more. So I'm curious, I'll ask the question. Who thinks the buyer is obligated at that point to go back and try for whatever's left in the period to get a loan? Anybody? Okay, that was the right answer, in my view. But again, and this is where, in my experience, this is one of the more frequent situations where a buyer and a seller get into a, I'm calling my lawyer, see you in court kind of communications with one another. And it's why documentation is a really, really good idea. It's a really good idea that even though the practice of mortgage brokers and sometimes lenders is take down the information from a prospective loan applicant on a blank piece of paper, and later the loan application gets printed and signed only at closing. But because you would expect an application to be the first thing that goes to the lender. But the standard practice is often that that gets prepared as part of the lender's closing package and isn't prepared up front. It would be my advice to a buyer to insist that the mortgage broker or the lender require the written application so it can be signed and dated, and there's a really good trail of paper that says the buyer did what the buyer was required to do, and that is diligently pursue the loan. Because the ultimate answer to your question is the seller can say, you have to go back and try harder, only in a circumstance where the buyer didn't do what's minimally necessary to get a loan, which is essentially apply in a timely fashion and to then follow up on information requested by the lender. And that's what, you know, if it ends up in court, that's what everyone tends to focus on. Be right with you in just a minute, Karen. Yes?
What about getting a loan commitment that has contingencies on it?
Oh, really good question. The question is, what if the buyer gets a loan commitment, but the lender has put contingencies into the loan commitment that says, we'll give you a loan, but only if, you know, you get your mother-in-law to co-sign the note, or whatever it is the lender thinks is important from their underwriting standards. Is that a commitment that makes the contract go hard and the financing contingency fulfilled, or no? I think it depends. I think it's both no and yes. I think that it would depend on what those contingencies are. I think that if they're unusual contingencies, like your mother-in-law needs to co-sign the note because she's rich and you're not, that would be one where I think the buyer could say, I didn't get the loan. But if the contingency is you'll execute all of the documents reasonably required by the lender at the closing, or you'll certify in writing your Social Security number and sign an authorization to get a copy of your tax returns, those are such standard provisions made by a lender as a condition to closing a loan that I think in that circumstance the buyer would not be able to say that this is not a real loan commitment. And that's what it boils down to. Is it a real loan commitment or is it not? Something else in the agreement is it provides that a pre-qualification letter or a pre-approval letter is not a loan commitment. Because most of us know those are pretty freely given out. You know, I could call my friendly mortgage broker or my friendly residential lender and say, I'm making this much money, I've been working this long, and they may write a pre-approval letter, which is always conditioned on underwriting. It's not a commitment.
So if there are contingencies and buyer says that isn't no problem, and then in the end the lender does not give the loan after they received a commitment, is the buyer in default?
You kind of have a royal mess on your hands, for sure. The question is, suppose that the buyer gets a commitment letter, there are contingencies that the lender has put into the commitment letter with regard to the loan, and the buyer says, I think I can satisfy all those contingencies, this is great. And then we get to the closing, and for whatever reason, the lender says, we're not making the loan. The question is the buyer in default? And I think that would depend on so many factors that it would be really difficult to sort out. It's possible that the buyer could be. It's possible that the buyer couldn't. In most cases I've seen, and I've seen some cases where, surprise, surprise, closing day comes and the lender suddenly says for some reason, we're not making this loan. That generally speaking, I think it's more likely that the buyer would not be in default if the buyer had diligently pursued satisfying whatever contingencies the lender laid out. And a lender then, of course, can have some serious lender liability in a circumstance like that. But, you know, that's just sort of a lawyer full employment kind of situation in my view. Karen.
In the discussions involving this particular part of the contract, we lovingly called it the S clause.
Okay.
Based on the hours were spent working on this particular part of the contract. But I would say to Kathy's question, I think that line 125 really attempts to try to answer that question about the loan commitment. I can read it, or everybody can just read it. I mean, loan commitments have just become a total pain in the ass, who knows. But we did, and this was actually old verbiage, because you can see that it's in black. But there's specific instances where the loan commitment, you know, I mean, basically, if the buyer doesn't like the terms of the loan commitment, the buyer better speak up and say, I'm not going to live by these terms. If they have to pay off a $50,000 hospital bill or something, you know, whatever's in that loan commitment, I think that they're going to basically be held to lose their deposit if they do not fulfill the terms of the contract, unless it's property-related conditions, unless the bank fails, unless seller defaults, unless, I mean, you can see the specific items that have been spelled out there. So, I mean, I think lawyers could always hash out anything at your point, Wayne, but I do think that the contract attempts to answer. If they want to get out of the loan commitment, they better get out of it before their loan commitment period is over instead of just letting it ride and seeing if they... And then I think the other point that's important to make is that if they do get, if nobody has a loan commitment and they get down to the closing date, they are losing their deposit.
Oh, right, if they don't close.
If there's no loan, right. So before, whereas we could get to closing and then the seller just said, the buyer just said, something didn't happen, then we were duking it out. At this point, in this contract, they are losing their deposit.
And I'll say a couple of follow-on comments to Karen's. Karen, I agree that every attempt has been made, and this is true with each iteration and version of FAR-BAR, that we draw on the experience that we've had so far, the court cases that have been decided using this form, and we do our very best to address all the reasonably foreseeable circumstances that could occur in an ordinary transaction. And so I agree with you that I think we've now made some progress in that regard, that there's going to be fewer opportunities for lawyers to get involved and argue what the outcome should be. But that said, it also depends on documentation, and not only documentation of a really well-crafted agreement where all the blanks have been dealt with, all the pages are initialed, you followed all of that. But remember that from that day, the effective date, which is now delivery, from that date through the closing, document everything. You're far better off that if you have any question at all, memorialize it, even if it's just a memorandum to your own file. This happened today, I had that communication today. That's, in my view, what makes a question or disagreement ripen into something as serious as a lawsuit is there's not enough documentation, and therefore many opportunities for the lawyers involved to fill in the blanks with whatever serves the side they're advocating.
Right. And just one other thing to Scott's point that I wanted to point out, the thing that I didn't realize, we actually have the ability to contact the buyer's age of their mortgage company, and so if there's any doubt about their ability to get the loan commitment or whether you feel like they're lying, right in line 105, you can contact the mortgage broker and find out exactly what's happening with that.
We always have that.
Yeah, isn't there a privacy clause?
I'm going to stop for 1 second. Are any of those questions coming through on the tape?
Yes.
They are. Okay, good. So we don't have to make everybody come up, but I'll repeat it if I think someone hasn't heard it or it didn't seem loud enough. But please do try to speak up. Scott.
Isn't the lender in a position where they're not allowed to divulge information about a file that you're not on?
Unless there's a written authorization to give a third party access to that information, yet the answer would be yes.
So the third party documentation, the same one we use in the short sale kind of thing, that is not in this verbiage, right? So how do you actually get that?
It is.
It is.
Yes. And we've always
So in the contract, it now stipulates third party access to the lender.
It always has.
Right. So that, yes, you're on the seller side of a transaction. You want to know what's going on. You're not getting communication from the buyer or the buyer's broker. It's kind of making the seller nervous. Someone else knocking on the door. I'd rather buy the house. You have this authorization to make inquiry, and the lender would be wise to ask you for a copy of it beforehand. Margarita.
My question has to do with, let's say everything's fine, but the insurance now, they go now looking for insurance, and it's like, $34,000 for a windstorm. I've had one of those. And the guy, the buyer says, I can't do it.
Didn't that come in with financing?
It's been addressed.
Yeah.
We've got an addendum.
Oh, you do?
We've had an addendum for it, yeah.
And we're gonna get to that. But you know, all of us know that when someone's getting financing, there are a host of costs that go along with it. Windstorm's a great example. One, because it's so high with no apparent end in sight. People who are coming from an area outside of South Florida are often not familiar with it, and they're sort of like, well, what could insurance be? And are in for a rude awakening. I think you'll have better likelihood of a deal that goes from contract to closing if you're even more aggressive than the forms in terms of going through with the buyer, you know, have you given thought to this? What's your parameters for insurance? All that sort of thing.
That's why it hasn't come up in the financing part because we're dealing with new groups now, but yeah, I do that. The other thing is that yesterday I spoke to an insurance agent, I didn't know this, that I think October 1st is a new rule about flood insurance that was passed by Congress.
Yeah.
So,
It's in here too.
Yes. In fact, I was just about to talk about that, but yes, that's in here too. Particularly with regard to a residential property that's not a primary home. There's now provisions, I may end up repeating it because I have a cheat sheet here I'm going to try and get through. There's a provision that basically says, you know, be ready for an unexpected cost here, number one. And number two, you may be obligated to incur the expense of getting an elevation certificate, irrespective of what the flood insurance premium is. In my experience, every flood policy requires an elevation certificate unless you're in one of those zones that they exempt out of it. Yes?
I was just going to reiterate what we were just talking about. I had a client, and he had a certain budget for a place he wanted to look underwater. One of the things I did before we didn't want to put an offer in, I said, please contact this insurance agent, find out what it's going to cost you, and he was shocked. So it stopped all that paperwork and everybody's time and effort because they couldn't do it.
Right, and then if that's a deal breaker, you can then turn your attention to the next opportunity and not have squandered it on something that's not going to work out. And all of us who have been here for a while, we know that this can often be a sensitive issue. Any other questions? Michael?
I think it's good that we're talking about the flood insurance. We're going to have a complete discussion about flood insurance itself because, as Margarita said, that law actually went into effect in the summer of 2012. It's called the Biggert Waters Act. FEMA has been phasing in different parts of that law, and people have been getting quotes from insurance agents based on the insurance agent software up until now that will drastically change after October the 1st. And some of them, their software didn't even permit them to tell people what the rates would be after October 1st. So people that have gotten policies this past year are going to be in for a rude awakening when their policies renew later. It's a real mess. Flood insurance is going to become even more problematic than windstorm insurance has been.
In some cases, it's higher. Even for people that are already homesteaded and had the same thing going on, my particular one is now higher than my ridiculous windstorm.
I was shocked at my flood bill this year, which happened just recently. Michael, I don't know if we've done it recently, but at times in the past we've had a lunch. And sort of a lunch and learn opportunity. So that would probably be a great subject. I think you could probably cover what needs to be covered in an hour, supply the materials, but I agree. And it will save a host of headaches. You know, I often say the reason we now have, we just passed it by the way in July, as of the results of the July bar exam, there are now more than 100,000 lawyers in the state of Florida alone. And the one single reason that drives that number more than any other, in my personal view, this is an editorial, nobody likes surprises. That people usually get sideways on an agreement or some other situation because they had an expectation and reality showed up different than their expectation, and that's unsettling for most of us, whether it's super negative or mildly negative. And that's why I always advocate really great documentation and a paper trail, because it better serves modifying people's expectations where it's appropriate to do that. I have one question and then we're going to take a break. I always get concerned that maybe you all are like I was in one of the many classes I've taken where I'm like, I can read. I don't need you to tell me what's on this piece of paper. Is this working for you, this format? Okay, great. It's working for me too. We're going to take a break for 10 minutes and we're going to come back and pick up where we left off.